All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning, everyone. We're here in CV210168, City of Flagstaff versus Desert Mountain Energy Corp. As you may know, we record and live stream these proceedings, so if you would please give your name and the name of your client when you begin. According to current protocol, you'll each be arguing from your own podium. You have a maximum of 20 minutes per side, although you are not required to use all of your time. We do require that you keep track of your own time, and the clocks on the podium will reflect your total remaining minutes, including any amount of time you would like to reserve. Please keep in mind that we have read the briefing, we've studied the record, and we have conferenced this case before we appeared this morning. So with that said, Counsel, you may proceed.
Your Honor,
sorry.
That's okay. I think we mixed it up with the clerk. We're actually the appellant on this side.
Okay.
I think we're on the wrong side. Cecily Stamps, representing the appellant and defendant, Desert Mountain Energy, and with me is our attorneys, Lisa Ann Smith and Tyler Stanton.
Good morning. I'm Chris Thomas with Perkins Coie Law Firm on behalf of the City of Flagstaff. With me today are Derek Peterson from Perkins as well, and Sterling Solomon, who is the Flagstaff City Attorney.
Okay. And you are free to leave your mask on or remove your mask as you feel comfortable, especially while you're speaking. Thank you. All right.
Thank you, Your Honors. This case involves the issuance of a preliminary injunction. The trial court below found two bases for the preliminary injunction. Two claims gave rise to the preliminary injunction, and one was breach of contract, and the other was declaratory judgment with respect, saying that Desert Mountain Energy, who I will refer to as DME, must apply for an aquifer protection permit, which I will refer to as an APP as we go forward. I'm going to address each of these. Neither of these claims support the issuance of the injunction. The breach of contract I'll address first. The breach of contract claim is entirely based on a license agreement, which can be found at Exhibit E of DME's appendix on appeal. The license agreement was between the City of Flagstaff and DME. It granted DME the right to cross city land to access state land in order to perform seismic testing. And then it also allowed DME to perform some seismic testing on city land. And what the license agreement provided is that the license fee for this access would be waived in exchange for a copy of the report compiling the seismic testing that was conducted on city land. That can be found at paragraph 3 of the license agreement. There is nothing in the license agreement that required DME to conduct seismic testing on city lands, and the only consequence for not providing the report from any testing that was conducted is that the city can charge a license fee. The first amended complaint filed by the plaintiff, the appellee in this matter, in their section on the breach of contract, they say this, and this is on page 16 of the first amended complaint, that as a result of DME's material breach of the DME license agreement, the city has been harmed in an amount to be proven at trial, but in no event less than the full amount of licensing fees it waived in exchange for authorizing the testing that DME completed. And that's all they say about the consequences in their first amended complaint. In other words, even the city recognizes that a breach, if it occurred, and DME disputes that there was a breach of contract, but even if there were a breach of contract, it can be remedied with money damages. And therefore, it does not give rise to the preliminary injunction that was issued in this case. The second claim is about the declaratory judgment that DME must obtain an aquifer protection permit, an APP. The preliminary injunction states that DME shall cease and desist any well construction or operation of the well or at the site of well permit 1255 until or unless it obtains all necessary permits, including an aquifer protection permit. In other words, the trial court found that an APP is necessary and ordered DME to obtain it. Now, DME denies that it is required to obtain an APP because it does not intend to engage in any of the conduct that would require an APP, and Their CEO unequivocally testified at the hearing below that if DME were to engage in any type of conduct that required an APP, it would obtain an APP. However, that's disputed by the city. The testimony is disputed by the city. This doesn't matter because the court doesn't have to resolve any dispute about this. Because to the extent the city believes that DME does not have the necessary permits, there are statutory processes to follow to raise that issue.
So your argument is that we don't even need to get to the factual findings or set aside any factual findings or relook at any factual findings because the claims themselves are not proper claims for a preliminary injunction.
That is correct.
Okay.
The statutes 27513 and 49261 provide clear processes for when somebody believes that under the oil and gas statutes or the water quality statutes that there is some kind of risk being posed. Under the oil and gas statutes, it grants the commissioner of the Arizona Oil and Gas Conservation Commission the power to issue permits, which it did in this case, and to sue when there is a violation of the oil and gas statutes. And it provides that somebody can file a complaint with the commissioner. And if within 10 days the commissioner doesn't act as the person who is adversely affected or believes they're adversely affected, if the commissioner doesn't do something, then they can bring an action, but they have to name the commissioner in that action. And similarly, under 49261, this gives the director of the Arizona Department of Environmental Quality the power to address violations of water quality statutes, including whether somebody needs to get an APP. And a person whose interest is adversely affected by the failure of the director to take action in such an instance, well, first of all, they can file a complaint with the director, and then if the director fails to take action, again, they can bring an action, but under that statutory scheme, they're supposed to bring an action against the director. And the city didn't do either of those here. And still, a year later, since this whole thing first began, there is no evidence, the city has presented nothing to suggest they've gone to the commissioner or the director of AZDEQ to raise any concerns about the well project at issue. It makes sense that the director and the commissioner should be a part of any litigation over the issue of a well project like this because they are the experts. They have the regulatory experience and expertise to weigh in on whether or not something requires an APP or whether or not a permit was properly issued or whether or not a project is being conducted within conformance of the regulations and laws. And if the city had followed the proper procedure, then the trial court in this matter would have had the benefit of that expertise. The city, in their argument, they cite language that statutes about common law claims not being abrogated by the water quality statutes, that they can bring common law claims based on that language. But a claim that DME must obtain an APP is not a common law claim. It is a claim arising entirely out of the statutes that create APPs and create the need for them, the existence of them, and the regulation which is under the jurisdiction of the director of AZDEQ. So I would say that because the city does not even have standing to request the declaratory judgment, it was an abuse of discretion for the trial court to issue an injunction based upon a finding that they were reasonably likely to obtain such a declaratory judgment. And I would like to note here also, there is another process for raising objection, which is the attorney general or the county attorney in an affected area can file complaints and even seek a TRO. But there is nothing in the statute, this is exclusive to the director of AZDEQ, the attorney general, and the county attorney. And that is set forth in ARS 49262. But there's nothing that gives a city attorney or a city the right to seek this. And so leading into the 4 criteria for a preliminary injunction, the first one is strong likelihood of success on the merits. The breach of contract claim, because it can't support an injunction, it doesn't even matter whether there's a strong likelihood of success on the merits. The issuing of the APP, again, because the city does not have standing to seek the APP, there is no likelihood of success on the merits under the law. With respect to a realistic possibility of irreparable injury, all the evidence offered by the city is purely speculative. Again, it isn't actually necessary for the court to even get to a finding about this factor, because there is no basis for issuing the injunction to begin with. But even if you look at the testimony, all the testimony from the city, all the evidence is, if DME does this, then that might happen. If DME failed to do X, then Y might happen. If the seals on the well cement bond are not sufficient, then this contamination could happen. But they offer zero evidence of any actual problems. Nothing that DME did wrong. It's entirely that they are afraid DME might have done something wrong. Well, DME is subject to a highly regulated industry. They applied for and received a permit from the agencies that regulate that. They have complied with all of the rules and all of the laws related to it. They've not been found by the regulating agencies to be in violation of any requirements, and they should not, the city should not be allowed to unilaterally halt their project, disrupt the settled rights of DME, simply because they have some undifferentiated fear that there could possibly be an issue. And I will reserve the rest of my time. Thank you.
Okay, thank you.
Thank you. It's hard being short. Let me start with Council's argument and the reply brief. First off, I think I'd like to just mention a few of the facts, because this is just not a narrow issue of law. But as the record reflects, City of Flagstaff many years ago started investing in a future water supply in anticipation of both continued growth and fearful of drought conditions in Arizona. Red Gap Ranch was purchased to provide a future water supply for the city at great expense. Indeed, the cost of that exceeded the assets of DME as a company. The future is now. We've had significant drought. Flagstaff has
Council, what if we just assume that irreparable harm would come to the aquifer if chemicals leached into it? I mean, let's just assume that the facts that you've stated, that this is their future water supply, and I don't think that was disputed at the hearing, or any contrary findings were made of that fact on the record. But even given that, everyone agrees that that would be the case. How does DME apply for an APP when the regulations require them to state when they would be drilling, what they would be used, what chemicals they would use, and where they would be drilling? If they aren't doing those things, how could they ever expect to get an aquifer protection permit?
Happy to address those questions. Let me first mention, since opposing counsel said the city offered only, quote, speculative evidence about the threat to its aquifer and production wells, if we're now conceding that the record is that there is a real threat, then I'll leave the facts alone. With respect to the legal argument, there's sort of two arguments here. One is, as a legal proposition, DME contends that in this particular alleged breach of contract, injunctive relief is not an appropriate remedy. I believe that DME has now conceded, for purposes of argument today, that there was in fact a breach of the license agreement, and so their argument...
Okay, and that's a different question, and I have questions about that as well.
Yeah.
But my question
Okay,
is, there's a preliminary injunction in place right now where a company can't further use their well until they obtain an APP. And my question was, how could that company obtain an APP if in fact they're not adding stimulants? How can they answer the questions on an APP application of the when, where, and how? How do they get out from under? How do they satisfy this preliminary injunction under the terms that the judge set?
Then they do what everyone else does in similar position. They seek a pre-application meeting with the Arizona Department of Environmental Quality and say, we would like a permit, we would like an APP permit that would allow us to do XYZ during the term of the period permit. And they would get a permit issued in due course once.
But don't the regulations say that they have to have the where, when, how to obtain the permit?
Well,
how would the DEQ know whether the permit would be something that they want to issue if they don't know the when, where, how.
Well, that's exactly the point, Your Honor, and the reason why the city brought these common law causes of action. Let me take a brief divergent. Since the First Amendment complaint was mentioned in counsel's argument, there are nuisance, negligence, trespass claims asserted in there. So the city's claim is not limited to the argument that we believe that common law tort claims are valid to the city here because, among other things, DME breached its duty to obtain necessary permits. But
the
part
court
of
didn't make
the
any findings of fact on any of your common law claims. I mean, are you in agreement with DME that the only claims that the judge found a basis for the preliminary injunction were the contract claim and the APP claim?
Well, but the APP claim is broader than it's been characterized. So even the non-amended complaint set forth the elements that later were expressly articulated as nuisance, negligence, trespass claims.
But did the court make any findings that there had been a nuisance or a trespass in the findings of fact?
The court found that there was a threat to the city's drinking water supply in the findings of fact and conclusions of law.
Right, but don't nuisance and trespass claims have specific elements that have to be met? I mean, my reading of her findings of fact were that on the APP claim, that she was only being asked to decide whether that statute applied. And her decision was yes. I mean, she's the one that kind of cabined that into something very specific, which is, does the APP apply? I just don't see any findings in here about that it was a nuisance, that there was a trespass, that past what you've told us, that obviously there would be irreparable injury to the water supply if chemicals leached. But as to any other elements of those common law claims, am I missing something in the findings of fact?
Well, yes and no, Your Honor. The first off, it's undoubtedly true that Judge Nichols relied only on the first complaint in making her rulings. On the other hand, the findings of fact are replete with establishment of elements of those common law causes of action. For instance, if you look at the findings of fact on pages 13 and 14, she found that the city had established a strong likelihood that it would not only prevail on its breach of contract claims, but also that money damages would be insufficient. And the reason for that is set forth, among other places, in...
But how is that the trespass or the nuisance claim?
Let me finish answering your first question, which is if you look at paragraph 7, what the judge found and the city had complained about was one of the reasons the city wanted DME to undergo the permitting process is the APP program.
I think the problem is I don't see you actually answering Judge Bailey's question, because the place that you've directed us to in the findings and conclusions is explicitly within the breach of contract section. And I think what we're trying, or as I understand Judge Bailey, is attempting to direct you to whatever portion we may be missing of the findings and conclusions that speaks to the common law claims that you have articulated, the nuisance and trespass claims. Paragraph 7 that you have pointed us to is explicitly within the breach of contract findings.
It is, and the questions are piling up here, so let me try to
Well, they're all getting at the same thing.
Yeah, and
if you could go there, that would be great.
The record is clear. There's a threat to the city's water supply. Part of the reason why the APP is relevant here is that the APP process itself is designed to develop information to ensure that well drilling and well operation is safe. So, for instance, the same sort of seismic contaminant risk information that was subject to the license agreement and which is missing, as Judge Nichols found, is what needs to be collected to obtain an aquifer protection permit. So the city's fears that its water supply wells would be impacted by DME's operation would be answered in part by DME undertaking the APP permitting process. Hopefully that's the answer to the question you asked, but
It doesn't, because I guess that my issue is that if we take on its face that you could have brought common law claims, you could have brought, I mean, in your preliminary injunction, you talk about the misrepresentation, fraud claims as to the state license that they did get. So you brought the APP claim, the contract claim, and a misrepresentation claim. But the findings of fact, as they're laid out and have headings and findings, the court only seemed to be making findings on the APP claim and the contract claim. And I think you had a right to bring a nuisance argument and try to get a preliminary injunction on the issue of nuisance. But I'm not sure if all you're bringing is contract and the APP claim, whether you can then say there are other common law claims that were included in these findings of fact. And that's what I'm confused about, is that, I mean, I noticed in your answering brief that you said, you know, all 11 of our claims support a preliminary injunction, which may have been true, but aren't we just restricted to the evidence that was presented at the preliminary injunction hearing and the findings of fact and conclusions of law of this court? And if we are, then I don't see any findings of any of your other common law claims that would support a preliminary injunction. And I'm asking you so that you can give me the argument on the other side.
Okay, well, first off, we had a little bit of convoluted procedural history below. So the preliminary injunction hearing was actually held on January 8th. The city's first amended verified complaint, which include the common law claims, nuisance, negligence, trespass, was filed January 4th, 4 days before the hearing. So that's now the operative complaint, but as Judge Nichols' order references, for purposes of the preliminary injunction hearing, she devoted her attention to the declaratory judgment claim and the breach of contract claim. With respect to the question about what evidence is in the record, despite the fact that the judge's conclusions of law were devoted to discussing those two causes of action, breach of contract, declaratory judgment, there's a host of evidence about the fact that negligence, trespass are indeed valid claims here. So if your question is, did Judge Nichols articulate, expressly reference claims in the first amended complaint that was filed 4 days earlier in her order? No. On the other hand, if your question is there evidence suggesting that the city's nuisance, negligence, trespass claims have merit? Absolutely. It's all over the record.
But doesn't the judge have to have granted the preliminary injunction as to those claims or on the basis of those claims? I mean, to the extent that Judge Nichols granted the preliminary injunction only on the basis of the APP and contract claims, if we were to find, as the appellant contends, that neither of those claims obtain PI relief, then aren't we sort of stuck with that universe as it stands?
Well, I think, Your Honor, that you're stuck with the universe of the record in its entirety.
And isn't part of that record that the preliminary injunction, you asked for a preliminary injunction just on 3 claims, the contract, the APP, and the misrepresentation on the Arizona mining application. So, I mean, I don't know that she would, and tell me how this works if I'm misunderstanding, but she couldn't have made any kind, you couldn't have presented any evidence on those other claims. The other side wasn't on notice that those would be brought up. How could she have made findings on a nuisance claim that was clearly part of your First Amendment complaint but was not a part of your application for preliminary injunction?
Here's where I think I've confused you, Your Honor. The misrepresentation claim that was addressed in the First Amendment complaint and the declaratory judgment, basically that claim was based on the totality of circumstances here. DME owes, threatening the city's potential future water supply by skipping all the collection of information that's necessary to assure us that they won't impact our wells. And so the absence of the APP and the underground injection control permit were illustrative of DME's failure to satisfy its duties to the city and to the public. DME keeps sort of characterizing the city's declaratory judgment claim as a narrow one that's limited solely to failure to seek an APP, which is why they contend that our common law claims are preempted by the availability of a citizenship under that statute. That's wrong as a matter of law, but it's also improperly characterizing the breadth of the city's declaratory relief claim. As it happens, since the sort of elements intertwined with the declaratory judgment breach of duty theory at the hearing, correlate quite closely to the common law theories that were later expressly advanced in the First Amendment complaint.
Okay.
Happy to answer any questions that you don't think I answered, or any new ones.
Tell me how, I didn't see, I'm unclear, and I'm not asking you to explain her findings, but it's a real conclusory finding under the breach of contract claim that the claim, your licensing agreement was for the waiver of the fee to traverse the property to get to the well, and seismic data that wasn't the data that wasn't turned over to you. So what in this record did the judge rely on that the contract claim couldn't have been remedied by money damages? Because DME has brought up that certainly was what you requested in the complaints, and the First Amendment complaint was that monetary damages, I assume in the form of the license fee and the cost of seismic testing, was what you were seeking. And I don't know what there is in the hearing transcripts or in the judge's findings that lend itself to the fact that this contract claim could not have been remedied by money damages. And certainly the second part of that question is, okay, even if it couldn't, how does refusing to let DME access the well have anything to do with the contract itself? And I liken it to saying, Judge Bailey, you cannot, we are enjoining you from drinking any iced tea, and by the way, you can't drive the car home that you drove to the courthouse with. I don't see the connection between the contract claim. If the APP went away, how does that support the rest of the remedies in the preliminary injunction?
Well, the license agreement was part of the big picture, which was DME basically reassured the city that they would ensure that their helium well upgradient of the water ranch was completed in a safe fashion that wouldn't jeopardize the city's water supply. So the seismic data that was contemplated by that license agreement was one step in that iterative process. And ultimately, you saw in the record, DME's position is that turns out that the seismic data that we were supposed to give FLAGSTAFF as consideration for the license agreement was worthless. Well, I guess that's an argument for why they satisfy their contractual obligation, but that just reinforces the fact that DME has not taken the appropriate precautions, has not collected the appropriate scientific evidence here.
But as to the contract, if you're looking at the four corners of the contract, why isn't your remedy the cost of FLAGSTAFF hiring their own expert to do seismic testing, or ordering that the data, whatever data they have in full form, not just screenshots of data from a computer, but whatever data they possess that they have done, that be turned over? Why isn't that your remedy as opposed to, well, you just can't mine, you just can't access that well? Why isn't it a monetary? What other relief do you seek out of the terms of that contract that isn't monetary?
Because the terms of the contract called for DME to provide the city with scientific information that would address its concerns about water quality.
Right.
Those concerns have not been satisfied because that information has not been provided, and in fact now it looks like it hasn't been collected.
And so your position is that cannot be collected otherwise?
Our position is that Judge Nichols was within the law and did not abuse her discretion in joining DME under the contract theory until that obligation is satisfied.
Right, but to the question of how is it that the lack of seismic data cannot be remedied by monetary payment? I mean, Judge Bailey posed an example of FLAGSTAFF hiring someone to obtain those, to do the work and obtain those results. Is that not possible?
Well, I think, as indicated by your ruling on the other cause of action regarding declaratory judgment, Judge Nichols clearly shared our concern that DME had no intention of complying with Arizona law. The same seismic data that it declined to collect as contemplated by the license agreement, it has declined to collect by refusing to seek an aquifer protection permit.
Right, but the question is, so FLAGSTAFF is in a situation where it cannot obtain that information by other means. Is that what you're saying?
Well, FLAGSTAFF theoretically could, commission its own information, but when you look at the totality of circumstances and Judge Nichols' order, she basically told DME to slow down and do this right, and among the doing it right requirements is to collect the seismic data that was both contemplated in the license agreement and also required for DME to comply with independent law.
But just because Judge Nichols ordered that be the step taken, that does not mean that there couldn't have been some alternative way which could have been accomplished by way of receiving monetary payment from DME.
Well, I'm not aware that DME ever suggested an alternative because they denied any liability at all on the breach contract theory. But in any event, the question for this court this morning, of course, is whether the remedy fashioned by Judge Nichols was an abuse of discretion.
Can I take another minute just because we're going to have some extra time? I just want you, before you sit down, to address the idea of the statute itself not calling for a private right of action, that there's clearly seemed to be in the statutes a method by which, you could make a complaint, or you could have the county attorney or the attorney general, and we all know the statute. And so I just wanted you to speak to, if the judge is ordering that the APP be complied with, then why isn't it a natural consequence that the APP be complied with, including the procedural aspects of the APP as to how a complaint gets made and who the proper party is to sue when you have a grievance about how that statute's been applied?
Well, DME's position is that the availability of a citizen suit remedy to the public calling for DEQ to undertake enforcement action, that's good as far as it goes, but in order for their position to prevail, they need to also have this court rule that citizen suit remedy, despite the fact that it explicitly says it doesn't preempt any common law remedies, and despite the anti-abrogation clause in the state constitution, nonetheless preempts all other remedies at common law related in any fashion to the permit. There are dozens of cases. The APP citizen supervision is pretty much the same as what you get in all federal environmental laws and other state environmental statutes. And that gives the public the right but not the obligation to ask the government to enforce against a party who is simultaneously not in compliance with law, but also engaging in tortious conduct. There's nothing in the citizen suit provision relied upon by DME that indicates that it's intended to preempt any other remedy at law, and in fact, it expressly says otherwise.
Okay, thank you.
Thank you very much.
Thank you. I guess following up on the final point that was being discussed, the city keeps saying that DME is not complying with the law and is engaging in tortious conduct, but at the same time that the city has no obligation to go through the statutory process to address exactly the things that they are concerned about. And they have not identified a reason why they have not pursued those. They just say they get to file these common law claims. But again, as your honors have pointed out in their questioning, the trial court did not find any common law claims supported the injunction at issue. It found the breach of contract claim and the declaratory judgment about the APP. And I think it is a disingenuous position of the city that they are taking, that they, on the one hand, want to try to circumvent the statutory process and at the same time accuse DME of engaging in conduct that would violate something that hasn't been found by the trial court. I think the city knows that if they went through the statutory process, they would not get the result that they want. And I think that the public policy, which is the final element, which I did not get to in my opening argument or opening discussion, is that's the fourth factor in when a preliminary injunction should issue, is whether the public policy favors issuing the injunction. The public policy of Arizona is set forth in its statutes, and there has been no reason offered to do an end run around those statutes. And therefore, the public policy does not favor issuing the injunction, even if the court were somehow to find that the rest of the factors did support it. With respect to the breach of contract claim, they only sought money damages. They have not articulated an argument as to how money damages could not remedy the harm that they say has been caused. They keep saying DME had an obligation to collect seismic data and to produce the report, but they didn't. The plain language of the contract is very clear. They had permission to use city land to collect seismic data, and they had permission, they would be allowed to do that without having to pay a fee if they shared the report. And to the extent it matters, which I don't think it actually does, the CEO's testimony at the hearing was they collected data from state land in order to determine where to site this well, and didn't rely on the data that they collected from the city land because it wasn't ultimately useful when they collected it. There's no breach of contract there, and there's nothing there to support the injunction. If they think that DME skipped steps for collecting data, which is what I've heard over and over in the argument this morning, is that DME avoided its efforts in collecting the data that would be needed in order to apply for an APP. They don't have any information that they could put forward in order to apply for an APP. And if the director of AZDEQ or the commissioner of the Oil and Gas Commission thought that DME had done something wrong, then they could take steps to investigate that and to address it. But they haven't, and the city hasn't asked them to. There's nothing in the record to support that, and even today they're not saying that they went through that process. There's simply no basis for the preliminary injunction here. And I know I have time remaining, but unless there's more questions, I think I've said everything.
Any other questions? No. All right, thank you.
Okay, thank you.
Council, thank you both for your arguments. We'll take the matter under advisement and issue a decision in due course. The court will stand in recess while we prepare for the next oral argument. Thank you.
Thank you.